I'd like to take this opportunity to introduce today's presenter, Jennifer Damon, Director of Compliance and Chief Privacy Officer here at AccuSourceHR. Jennifer graduated from the University of Akron School of Law with a Doctor of Law degree and has over 10 years of experience in the background screening industry. She is an experienced compliance professional with knowledge from both the employer and consumer reporting agency sides. She has performed various roles in the industry, including interpretation of criminal civil record summaries, managing quality control, and managing the E-Verify program, including audits for a billion-dollar facility services company. She has experience with government clearances and contract reviews. Jennifer is responsible for AccuSourceHR's compliance department, including federal, state, and local legislation changes and industry accreditation. Additionally, she oversees the quality assurance process. I will now turn the presentation over to Jennifer.
Thank you so much, Danielle. Good morning or afternoon, depending where you are. As Danielle said, welcome to the Year-End Compliance webinar. Before we get started, please keep in mind that you can send over any questions you have during the presentation. And as Danielle mentioned earlier, I'll make sure to answer as many of them as possible at the end of the presentation. Or if we run out of time or they're a little bit more involved, I'll address them by email after the fact. I was just talking to Danielle about this before we jumped onto this webinar. Where did the summer and fall go? If your work schedule has been anything like mine, the last 6 months have completely flashed by. We are not short in background and drug screening updates, so I will be addressing those here in the next hour. Specifically, I'm going to go over a few notable items from the mid-year webinar, but I'm going to be focusing especially on new developments from the past 2 quarters, including Ban the Box and Fair Chance Act legislation that's been recently updated or enacted, salary transparency, new privacy laws, and marijuana and related drug screening updates. We're going to wrap up the session by reviewing trends in the industry going into 2024. And as always, I'm going to share some best practices for compliant background screening programs. As usual, I need to start with my legal disclaimer. Even though I'm an attorney, this webinar is informational only. I am not providing legal advice whatsoever. Please reach out to your in-house or outside counsel, preferably one who specializes in employment law, especially in background screening law, and ask them for legal advice as you review your screening programs. First topic that we're going to discuss during this webinar is fair chance legislation. You also might hear us refer to it as ban the box laws. These types of laws prohibit employers from asking about criminal convictions before a certain point in the hiring process. So it can vary, but typically this involves waiting until you've made a conditional job offer or held an interview. There's various goals of fair chance laws. So for example, the first one is to allow applicants with prior convictions to obtain an interview, first of all. In the past, what was happening is they would see the response of yes to a criminal conviction question and they wouldn't even be interviewed. So this gets them farther into the process. As I mentioned, it allows them to move farther into the hiring process. Some of these laws also require that an employer delay the background check process until a certain point in the hiring process. These laws are definitely not going away. And typically, unless your organization is very limited geographically, for example, maybe you're only in one specific state, you're most likely already subject to these types of laws. So if you're not already in compliance, I would recommend that you review and get into compliance as quickly as possible. We're going to start with Monroe County, New York, which passed its Fair Chance Employment Act on August 8th, 2023. This law has a lot more limited application than others that we might talk about because it applies only to county job applications. For example, under this law, the county cannot ask about criminal history on job applications. They also cannot ask about arrests. However, the law specifically says that they are allowed to ask about pending criminal charges. The law also outlines what the county cannot consider, which includes expunged records, records of arrests, except for pending criminal charges, as I just mentioned, dismissed records, and infractions. It also specifies that Monroe County must make sure to still follow the New York Article 23A process. Like other ban-the-box laws, certain positions are excluded. For example, the law lists out the Sheriff's Office, Department of Safety, and other similar types of positions. You probably aren't going to be surprised to hear this, but California updated its laws again. This time, on July 24, 2023, California amended the 2018 Fair Chance Act, or FCA, as I'll refer to it very lovingly throughout this presentation. The amendments went into effect on October 1st, which gives employers little time to react. Because really, it only was amended July, so only a few months, really. The amendments provide some clarifications, specifying that the FCA applies not just to applicants for employment and applicants who apply for another position in the company. It also applies to employees whose backgrounds are checked due to a change in control of the company or a change in the employer's policies or practices. So for example, if a company is acquired and you want to background screen the new employees who are coming on board with the main company, the parent company, you still have to follow the fair chance laws, even though you're acquiring another company. The amendments also specify that employers cannot consider criminal offense information received directly from applicants or employees prior to a conditional offer. So in other words, if an applicant is being very honest and forthcoming and give you information, you have to ignore it. You can't consider it. Employers also cannot advertise or include in recruiting materials that they will not consider applicants with criminal histories. The FCA amendments also changed the adverse action process for California. Now, employers must consider more specific information before even sending out the pre-adverse action notice, which is called the initial assessment. The initial assessment must include consideration of a number of factors, including information that an employer typically doesn't even have at this stage of the process. So for example, they would have to consider the context under which the offense occurred, whether there was domestic violence or other extenuating circumstances that may have led to the conduct, for example, someone defending themselves, or other factors that could be included. Because employers may not have some of this information, they may need to ask for it before conducting the initial assessment. Another way some employers may do this is by providing kind of a questionnaire that gets filled out beforehand that they can consider. The amendments, however, are clear that employers cannot require the individual to provide this information. Where employers do receive the information, they cannot refuse to consider it. If you receive it, you have to take a look at it, but you can't force them to give it to you. The FCA amendments also extend the waiting period between pre-adverse and adverse action letters. The law now requires that an employer wait 5 business days after the applicant has received the pre-adverse action notice. So you're probably wondering, how do you know if the letter's actually been received? The employer must follow one of 2 options. First, you can send a letter using a method with delivery receipt, such as mailing it with a signature confirmation or delivery confirmation. Or the employer can wait a specific number of days before it can assume the letter has been received. Luckily, the law actually lists the typical time frame for each type of delivery method, so it provides guidance. For example, you can send the final adverse letter 2 business days after if you sent the pre-adverse letter by email, 5 calendar days after mailing to a California address, 10 calendar days after mailing to an address elsewhere within the US, or 20 calendar days if you're mailing it outside of the US. Another notable update to the Fair Chance Act is the expanded list of evidence of rehabilitation and mitigating circumstances that an individual can provide. As I mentioned earlier, if the individual provides this information, the employer is required to consider it. If additional information is provided, the employer still has to conduct the reassessment as it was required under the original version of the FCA, and they have to take the new information into consideration. It's also important to note that employers must follow the FCA, say that 3 times fast, confusing it with FCRA. So employers must follow the Fair Chance Act process, even if it learns of criminal history information from another source besides a background screening company. This really deviates from the way background screening is normally done, because typically background screening consumer report involves background screening company. But here, even if an employer decides to look up court records themselves, they still need to follow the process. So be very, very aware of that so you don't get into trouble. Ultimately, this updated FCA process has been in place for almost 3 months. So if you're already not in compliance, I highly, highly recommend working with your counsel to get into compliance as quickly as possible. If we continue to hear any feedback or updates on the process, as always, we will keep you posted. Let's move on to clean slate laws, which are becoming more popular. Technically, clean slate laws differ from ban-the-box laws, but they share a common goal, which is why I'm grouping them together here. The goal of clean slate laws specifically is to give former criminal offenders a clean slate, which is why it's called that, if a certain amount of time has passed since prior records and they have not had any newer records since then. New York State has officially joined the clean slate movement. It was signed into law on November 16, 2023. However, employers have a little under a year to get into compliance with it. It goes into effect November 16, 2024. The goal and the purpose of the act and what it's going to do, it's going to seal criminal records after the individual is sentenced or released from incarceration. There are caveats. For example, an individual cannot have been subsequently convicted of another crime. They also cannot be subject to probation or parole any longer in order for it to apply. As with other clean slate laws, there are timing requirements. Eligible misdemeanor convictions will be sealed 3 years after incarceration. Or if there was no incarceration, it'll be 3 years from the imposition of the sentence, such as probation or a fine, whatever the sentence was. For eligible felonies, the time increases to 8 years from finishing incarceration or from the imposition of sentence if there's no incarceration. A couple of very important notes to keep in mind. An otherwise eligible conviction might not be sealed if that person is still on parole or probation. However, once they complete those programs, the convictions would then be sealed. Also, if that person's charged with another crime before the waiting period is ended, the record will not be sealed. There's also certain types of convictions that don't qualify for sealing, including sex crimes, murder, and other non-drug Class A felonies. The law will also not seal federal crimes or crimes under another state's laws. So how is this new Clean Slate Act going to impact employers? Employers are going to be prohibited from asking about or using applicants or employees' sealed criminal records. Doing so would be considered an unlawful discriminatory practice. For applicants or employees who are asked about criminal history, they generally can answer as if the sealed record does not exist. There are exceptions where employers can inquire into sealed records, but I will mention just a couple of them. For example, the Clean Slate Act does not apply to employers who are permitted or required by law to perform fingerprint-based background checks on job applicants. So think schools, police, positions like that. It also doesn't apply to employers who are legally required to conduct background checks for jobs involving children, the elderly, or other vulnerable populations. Again, schools. Employers may be concerned that they could face claims of negligent hiring if they can't access or even ask about sealed records. The Clean Slate Act does consider this concern. In a civil action, sealed records cannot be introduced as evidence of negligence. This assumes that the record was not otherwise provided to the employer, such as by a government entity. One last point before we move on to our next topic. The New York State Office of Court Administration has up to 3 years to implement the process to identify and seal all eligible records. When you really stop to think about this, this is actually really concerning because the office has up to 3 years to get processes into place, but the law goes into effect after 1 year. So how is this gap going to be addressed? Currently, we don't have an answer. However, because this law is so new, we're likely going to receive guidance before it becomes effective in 2024, and we'll definitely let you know when we receive that guidance. Let's move on to pay transparency. In the mid-year webinar, we reviewed New York State's pay transparency law, but I want to review it again due to some updates made since the summer. The law became effective on September 17th, 2023. Employers must now disclose compensation or a range of compensation when issuing a new job opportunity, promotion, or transfer. In determining that range, it comes down to employers' good faith belief in what the range could be at the time the employer posts the position. The range can extend from the lowest to the highest hourly wage or salary. Employers are not required to provide a wage range for positions based solely on commission, but they do have to disclose that that position is solely commission-based. An employer must provide a job description if it already has one available, but is not required to create a new one from scratch. So who does this apply to? It applies to all employers with 4 or more employees for positions that can or will be performed, at least in part, in the state of New York. Notably, temporary firms and temporary employment are explicitly excluded from this law. In March, a bill was passed which updated some aspects of the pay transparency law. For example, the record-keeping requirement in the original law was removed. The original wording of the law included all remote jobs, but the updated law reduced down this broad application, which I'm sure was a relief to a lot of employers who have remote jobs. In this case now, the law only applies to jobs that will be physically performed in New York. It also includes any job, promotion, or transfer that will be physically performed outside of New York, but that reports to a supervisor, office, or other work site in New York. So even if the person's not going to physically be in New York, they could get pulled into New York if they're going to be reporting to someone in New York. Watch this last part especially because this shows that jobs that have no ties to New York could still require compliance if, as I mentioned, the job reports to a supervisor based in New York. The March update also removed record-keeping requirements, as I mentioned earlier. The definition of advertise was also updated, and it now means to make a written description of an employment opportunity available to a pool of potential applicants for internal or public viewing, including electronically. So the reason we're re-reviewing the New York pay transparency law is because there were proposed regulations published on September 13th with public comment until November 13th. The regulations reiterate the geographic scope of the law as we just discussed. So again, it applies to positions that are physically performed, at least in part, in the state. Remote positions, as mentioned, are impacted if they report into a supervisor or office in New York. The regulations also clarified that it's not enough that someone attends meetings or conferences occasionally in New York. That's not going to bring the position into scope. The regulations also include information on job descriptions. So if a job description exists for the position, the advertisement must include concise description of primary duties and responsibilities. However, as I mentioned earlier, the employer is not required to create one just to create one, but then also a job description is not required when the position or title clearly conveys the full extent of the duties, such as dishwasher. Regulations also clarify that all types of advertisements are covered regardless of medium if they are sent to a pool of applicants. It also specifies that the pool of applicant means more than one potential or prospective applicant. Job advertisements must list a specific pay range. So it's not acceptable to list $20 per hour and up, because that's not really a true pay range. However, if the position truly has a fixed rate and cannot be negotiated, it's fine to list that. So for example, if you're only going to pay $15 an hour, there's no wiggle room, you can say $15 per hour. In New York, they are not required to disclose other forms of compensation or benefits, such as health insurance and paid time off. However, I do want to mention a caveat that's very important. The salary range in the job advertisement must be for a single opportunity in a single geographic location or region. What does this mean? If an employer uses one advertisement to cover multiple geographic locations or different seniority levels, it must list multiple salary ranges for each individual opportunity. Put differently, cover job advertisements cannot list a wide range that applies to multiple locations or multiple seniority levels. So you can't say that anyone working in compliance could make between $10,000 a year and $500,000 a year. That's not acceptable for New York. If more space is needed to provide this information, the employer can provide an addendum or a hyperlink that shows different pay ranges. Finally, the regulations clarify the good faith requirement under the law. Employers must provide the salary range that they believe in good faith to be accurate at the time that they post that job advertisement. Good faith is defined as the range of compensation the employer legitimately believes they're willing to pay at the time they post the job advertisement. When determining that range, employers are allowed to consider the job market, current employee compensation levels, hiring budget, and acceptable experience and education levels. The law also specifies that employers are not tied into a pay range once posted. For example, say that the employer is not getting bites from the type of candidates they want. They can go back and adjust the range to attract better qualified applicants, or can even offer higher pay to secure a hire that may be asking for more money than was originally listed in the range. While the regulations have not been finalized as of this webinar, it's critical for impacted employers to come into compliance as quickly as possible, if not already meeting these requirements. We also have some regulations that were proposed for Colorado's updated Equal Pay for Equal Work Act. As a reminder, the amendments go into effect as of January 1st. If the regulations pass, they also go into effect that same day. So there could be very little time. So here, within 30 days of start date, employers must internally announce new hires and promotions, including the name, former job title, and new job title of the selected candidate. They must also provide information on how employees can demonstrate interest in similar opportunities in the future. The proposed regulation clarifies to whom notice must be provided by the employer. So it must be distributed to employees with whom the selected candidate will regularly work. So by regular work, it means that there's going to be at least some sort of monthly communication or collaboration, or if there's a reporting relationship. Employers can also choose to provide the notice to all employees instead of the targeted communication. The notice requirement also does not apply when a promotion is based on career progression or career development, assuming that there's no vacancy to be filled. So someone's in a position, they're promoted up into a new position, but there wasn't an official vacancy. It was just a true promotion. Another item addressed by these regulations is how to handle the application window requirement. As a reminder, external postings must include the date the employer plans to close the application. The regulations, if passed, will include two exceptions. First, there's no deadline to apply because the employer accepts applications on an ongoing rolling basis, referred to as evergreen job posting. If that's the case, a deadline's not required. However, the application must state that applications are accepted on an ongoing basis. Second, that deadline can be extended if the original deadline was made in good faith, and if posting, if the posting is, they need to update the information as long as they're promptly updating it, so that way potential applicants are aware that it's been extended. They can do that as well. Under the amended law, employers with no physical office in Colorado and who have fewer than 15 Colorado-based employees will be required to provide their Colorado employees notice of remote job opportunities only, rather than all promotional opportunities throughout the entire company. This is going to be in place until July 1st, 2029. However, the proposed regulations will update this a bit if they're passed. So specifically, the notice requirements for pre-selection, post-selection, and career progression do not apply to employees entirely located outside of Colorado. As we learn more about the proposed rules and whether they pass and in what fashion, we will let you know. Hawaii recently enacted pay transparency law that goes into effect on January 1st, 2024. It applies to all employers with 50 or more employees. However, at the time I was preparing this, it doesn't specify whether those 50 employees have to be 50 employees in Hawaii itself, or if it's 50 employees company-wide. So in the job listings, an employer must disclose the hourly rate or salary range that reasonably reflects actual expected composition for that position. It does not apply to positions that include internal transfers or promotions, and it also excludes public employee positions where pay and benefits are determined under collective bargaining. The new law also expands Hawaii's equal pay law in two ways. First, it prohibits pay discrimination on any protected category, not just sex. Second, the comparison between employees must be based on substantially similar work rather than equal work. The new bill does have separate enforcement provisions or remedies. Aggrieved parties can file a complaint with Hawaii Civil Rights Commission, and they also have a private right of action under Hawaiian law, meaning that they can sue a company that's in violation of the law. Phew, there's a lot of pay transparency going on. So Illinois recently amended its own Equal Pay Act of 2003 with the changes effective a little over a year from now, January 1st, 2025. It applies to all employers with 15 or more employees. The position has to be either physically performed, at least in part, in Illinois, or the employee would report to a supervisor, office, or other work site in Illinois. It applies to both external and internal job postings, plus any postings that are publicized by third parties, such as job search sites or recruiters. Employers are required to include pay ranges and benefits information in all job postings. Benefits can include other types of compensation, including bonuses and stock options, what actual range employees are currently paid for similar roles, and the amount budgeted. Pay scales have to be determined in good faith. They are allowed to consider previous ranges, what ranges are being paid for employees who are currently doing that role, and the amount that's budgeted. Instead of listing all this information in job postings, employers are allowed to provide a hyperlink to a publicly viewable page that provides that information. If an employer uses a third party to post jobs, such as a job site or a recruiter, the employer must provide the same information to that third party so that third party can in turn provide it. Employers also must make known to current employees any opportunities for promotion within 14 days of posting that position externally. Also, before asking applicants for wage expectations, the employers must first share the salary range. There is a record keeping requirement where employers have to create records to show compliance and then must keep those records for at least 5 years. There can be penalties. The Illinois Department of Labor can investigate and penalize companies that fail to comply with the law. The penalties are based on the number of previous violations and whether that job that's in violation allegedly is active or inactive. The Department of Labor also has discretion in determining those penalties. So the cure periods and penalties can range depending on whether the job posting is currently active or inactive. For active job postings, the cure period can range from not having a cure period up to 14 days to cure. Fines can range from $500 to $10,000. And keep in mind that would be for each job posting that's in violation. For inactive job postings, the fines range from $250 to $10,000. Our last update for this portion of the webinar comes out of Minnesota. SF 2909 amended the Minnesota statutes. It impacts all employers and is effective on January 1st. This amendment is a traditional salary history ban where employers cannot seek pay history. As with others, there are exceptions, such as where the applicant's pay history is public record, such as someone who's working for the federal or state government. The applicant can also voluntarily disclose pay history, which can then be used to support higher pay. Employers can provide information about the compensation package offered for a position and can also engage in discussions with applicants regarding compensation expectations or requests. There have been a lot of privacy laws enacted in 2023. Oregon and Delaware both passed privacy laws since the mid-year webinar, so I'm going to focus on those two. Otherwise, it would take up the entire webinar to look at just privacy, to be completely honest. So keeping that in mind, in the past, I usually reviewed each privacy law separately, but this time, since there's a lot of similarities, I'm going to compare them together in the chart form that you see right here. The Oregon Consumer Privacy Act, or OCPA, becomes effective July 1st, 2024, whereas Delaware's Personal Data Privacy Act isn't going into effect until January 1st, 2025, so about 6 months later. Both laws have thresholds that bring processing into scopes, but the scopes for each law vary. Both laws do apply when a business either conducts business in that state or provides goods or services to residents or consumers in that state. The thresholds differ though, as you can see. Oregon's law applies when the business controls or processes the personal data of 100,000 or more consumers, or 25,000 or more consumers, but derives at least 25% or more of its annual revenue from selling that data. Delaware has lower thresholds. Specifically, it will apply at 35,000 or more consumers, or at least 10,000 consumers, where at least 20% of annual revenue is derived from selling personal data. So most likely more data could come into the umbrella for Delaware. Both laws exclude individuals from the definition of consumer where that person is acting in a commercial or employment context. As with other US-based privacy laws, there's also various entity level and data level exemptions. So for our purposes today, some of these exemptions include entities and data involved with the Fair Credit Reporting Act, HIPAA, the Driver's Privacy Protection Act, and others. Employment data is also exempt. Both laws include consumer rights, such as the right to access data held on that individual, the right to correct or request deletion of that data, and the right to opt out of data collection and processing. Also, the same is the amount of time the data controller has to respond to consumer requests. The default time frame is 45 days, but a controller can extend it out another 45 days if it's reasonably necessary to comply with the request. So maybe, for example, the person has a common name, there's a lot of data to look through, there's extenuating circumstances, you can request additional time. That being said, the controller has to provide notice of that extension to the consumer so that way they're aware. Businesses also have various obligations under the laws. They must have a privacy policy that describes the purpose of personal data collection and processing. Controllers also must obtain explicit consent. First, when processing sensitive data, when processing the data of children who are 13 to 15 years old, who are specifically targeted for targeted advertising, profiling, or the sale of their data, or where personal data will be processed for a secondary purpose. Additionally, consumers must be able to revoke the consent that they gave. Controllers are also required to conduct data protection assessments when processing activities present a heightened risk of harm to the consumer. For example, some of this includes targeted advertisement, processing sensitive data, selling personal data, or using it for profiling. Finally, both Oregon and Delaware controllers and processors must enter into a written contract to govern the processing relationship. We will finish out our comparison of Oregon and Delaware's privacy laws by reviewing enforcement and cure periods. Neither law allows for private right of action, meaning that the individual can't sue on an individual basis. They can be enforced by a designated party, either the Oregon Attorney General or the Delaware Department of Justice. Oregon provides enforcement options that the Oregon Attorney General can take, include civil penalties of up to $7,500 for each violation. They can enjoin the violation or provide other equitable relief. Delaware's law is silent as to civil penalties, but violators may be forced to pay up to $10,000 for each willful violation. Both laws have cure periods, with Oregon having a 30-day cure period, but Delaware is more generous with a 60-day cure period. But that 60-day cure period is only going to be available until December 1st, 2025. Keep in mind that was a very quick review of these privacy laws, so please review the full requirements very carefully with counsel. I did also want to provide on a slide the laws that are coming up soon. We did discuss these in the mid-year. I'm not going to discuss them again for time restraints, but here they are again. And our final topic is marijuana and other drug testing updates. Specifically, we're going to review new marijuana protections, especially around drug testing. We'll also go over newly legalized medical and recreational marijuana. We've discussed new marijuana protections in California in previous webinars, so I'm not going to spend a bunch of time rehashing this topic. Yes, that pun was intended, but I did want to provide a quick reminder since it's going into effect on January 1st. Employers cannot discriminate against an individual in hiring, termination, or any other term or condition of employment based on that person's use of cannabis off the job and away from the workplace. There's also drug testing restrictions. Specifically, you can't discriminate against an individual for testing positive for non-psychoactive cannabis metabolites. This applies to hair, blood, urine, or other bodily fluids. The issue here is, even if a person's no longer high on cannabis, they can still test positive for up to 30 days. So that means that they could test positive even though they used it outside the workplace, maybe the night before, but they weren't under the influence at work. That differentiation makes it harder for employers to test for marijuana, especially for pre-employment purposes. There are some limited exceptions, and we discussed those in the previous webinar, so please revisit those if needed. Employers that do not meet an exception, though, you really should be prepared to remove marijuana from your drug test panels or otherwise adjust your screening programs as appropriate. California's treatment of marijuana doesn't end with just drug testing. In October, a law went into a place where it creates a ban, in essence, against considering prior cannabis use. So unless an exception applies, employers should update their policies for how they consider criminal background check results for marijuana. They should no longer ask about or consider past cannabis use, even if it's learned from a criminal background check. So how far does this extend? Prior use implies simple possession and use, so not more serious offenses like sale of cannabis. There are some limited exceptions where employer is allowed to ask or consider about prior cannabis use, such as under state or federal law. Generally, though, I'd be very, very careful with how you approach marijuana in general in California. I also wanted to provide a quick reminder on Washington's new law that goes into effect on January 1st. Similar to California, protects against discrimination due to lawful marijuana use, bringing marijuana more into line with alcohol. There are some workplace protections for employees who use marijuana off duty, but it doesn't protect all marijuana use. Employers can still have drug-free workplace policies, but they cannot refuse to hire a person due to lawful off-duty use of cannabis outside the workplace. So that in essence means like California can't really rely on pre-employment marijuana drug tests that test for non-psychoactive metabolites. If a Washington employer does want to consider continuing pre-employment marijuana, it has to use tests that are scientifically valid and that are conducted through methods that don't screen for non-psychoactive cannabis metabolites. There are some exceptions. For example, you can test for other purposes beyond pre-employment testing, such as reasonable suspicion. I mentioned if they can find a testing method where they're not testing for non-psychoactive metabolites, that could be allowed. If there's a state or federal requirement that requires testing, or if it's a certain type of position, such as safety sensitive. Moving on to medical cannabis. So Kentucky legalized medical cannabis effective January 1st, 2025. The qualifying medical conditions list is a lot smaller than other lists, but it did specify that other conditions could be added in the future. So typically here, the applicant will apply for a medical marijuana card after receiving a written certification from the practitioner showing they have a condition. And at that point, they are allowed to move forward with medical marijuana. Kentucky is very employer friendly. Employers can prohibit the use of medical cannabis, prohibit them from using equipment if they believe that they're using it unreasonably for safety. They don't have to allow the consumption of it in the workplace. They are allowed to still drug test and can act on positive results. And they are allowed to rely on the statute to shield against lawsuits and unemployment costs. Okay, mid-year, we reviewed Maryland's adult use marijuana law, which has been effective since July 1st. At the time, there weren't any information about employment and how it affects employers. So there was an FAQ issued asking, can I use cannabis at work? It says you can prohibit marijuana use, including off-duty. However, it's greatly recommended that Maryland employers add observed symptoms of marijuana employment to drug policy. You have to be able to show that they were actually impaired at the time and didn't just have it in their system from prior use. So Ohio, which was very surprising to me, became the 24th state to legalize recreational marijuana. It just became effective on December 7th and applies to adults 21 and over. They can purchase and possess up to 2.5 ounces of cannabis in plant form and can possess up to 15 grams of marijuana in extract form. Also permitted to grow marijuana at home, between 6 and 12 plants total, depending how many individuals are in that house. So how does it affect employers? Not much at this point. Employers have explicit rights under the new revised code. They don't have to permit or accommodate adult use cannabis at work or impairment. They can refuse to hire or take other adverse employment action against an individual due to use outside of work. Drug testing policies, zero tolerance policies are no issue whatsoever right now for Ohio. And if an employee is discharged due to cannabis use in violation of company policy, they're going to be considered to be discharged for cause, meaning that they can be denied for unemployment. The interesting thing is, I'm not going to spend too much time because I want to make sure we have time for questions at the end. The legislature can actually change the law because it wasn't a constitutional amendment. And both of those parties are already working on arguing against this law and trying to update it. So sometimes they might want to outlaw home growth or decrease the personal possession limit, or make sure that edibles are not in certain shapes, like shapes of bears, cartoons, and fruit. Nothing's come of that so far from what I've seen, but I'll definitely keep you posted if they do. So the treatment of marijuana remains very complex. So I hear all the time, I'm a multi-state employer. How am I supposed to approach all these changes and these differences? It's complicated. Always review these laws with either in-house counsel or outside counsel. They'll be able to look up case law and see how others are treating it and provide really great advice for you. They can also watch out for changes to existing laws and determine how it impacts you. No matter what, make sure you're documenting your policies. You have to make sure to treat everyone fairly, so follow those policies. Can't prove that you have a drug-free workplace if you don't have it in writing, for example. Make sure that you're reviewing your policies periodically and updating them to come into line. Consider whether exceptions apply to you and make sure you document why you think they do. And work with legal counsel to see if you have any limitations for drug testing. So as we prepare to enter 2024, what can we expect? California and New York are continuing to lead the way with clean slate and fair chance laws. Where these states tend to go, other states tend to follow. Pay transparency is going to continue to become more popular, as well as additional privacy laws. Privacy is still very critical as more and more states pass the law. Eventually, we might see a federal law. We'll have to see. Marijuana is taking a very interesting turn. So I live in Ohio, and I was very surprised that Ohio passed adult use cannabis because Ohio tends to be pretty conservative overall. So I'm almost curious to see whether marijuana is legalized in more conservative states going forward. Guess we'll have to see what it brings. Always interesting to see. So let's finish up with some best practice recommendations as usual before we take questions. Number one priority, always work with your legal counsel, as some of these issues can be complex and confusing. I honestly have to take a second look at a lot of these just to be sure. So work with your counsel, please. Review your background and drug screening programs to confirm you're still compliant as the laws are changing. We recommend reviewing at least annually and as needed. Update your employment applications and hiring processes to meet any Fair Chance Act requirements and pay salary laws. Make sure you come into compliance with those. Determine how new privacy laws impact your organization, especially if you're subject to more than one. Review new marijuana laws carefully. If you operate in more than one state, watch out for competing laws. Again, for any of these, we recommend a privilege review with your legal counsel to look at your current processes and make sure that you're compliant. We're now at the end of the presentation, and I'm going to turn it back over to Danielle, and we can take some questions.
Fantastic. Thank you, Jennifer. So we had a lot of great questions. One of the first questions is can conditional offers be made verbally prior to running the background check?
I would need to double check that. My concern, anytime that there's a requirement for a conditional offer, if you're making it verbally, how are you going to prove it? Even if you make it verbally initially, I'd probably recommend following up in writing. But let me do a little bit of digging on that, and I can provide a better response to that.
Fantastic. Next question is we are a behavioral health provider for children in Illinois and Virginia. Our employees are required to achieve and maintain a certification that does not allow any felonies at all or any misdemeanors that are related to children or violent behavior. We don't run the background check until after an offer has been accepted, but we do ask them if they would have an issue with us running a background check and if there's anything that they'd want to let us know ahead of time. How should we handle this?
So I want to look at this more specifically because it's very targeted to a specific situation. But I would think that if you're already in the offer extension phase and they've already conditionally accepted it, it's not abnormal. I've seen other employers before who either ask for information or they might provide a questionnaire that's even part of the background screening process, like a disclosure. So my initial instinct is that you can do it that way, but let me double check because as you mentioned, there's nuances with your specific example, especially because you're working with children and vulnerable parties.
The next question is California a slate state? And is there a list of that the convictions are?
Yes, so California did pass a clean slate law. I think I talked about it in a past webinar and I didn't cover it again because of timing concerns. So let me see what I can find and we could follow up via email because I'm sure that there's a list of similar types of offenses that'll be eligible, kind of like there were with the other states we went over today.
All right. Additional question can be, can employers test for marijuana for reasonable suspicion?
Generally, yes. For reasonable suspicion, though, make sure that you're following any requirements for signs of impairment. So for example, I can't remember what the state is off the top of my head. I always forget if it's New Jersey or Connecticut, but they require an employment workplace impairment expert or a similar position since they haven't actually defined that position or provided training requirements or certification requirements. But just make sure that you're following any specific rules for the states that you're in. They may require you to document. Honestly, I always recommend documenting because again, if you don't have it in writing and you need it for support, how are you going to prove that you did the impairment assessment? So generally, yes, but make sure you're following those different laws.
Great. How about this? My company posts remote positions that can be filled by anyone in the US. How should we approach pay transparency laws when we do not know where potential applicants might live?
So this is a very, very loaded question because I'm overly paranoid and I would probably say list it everywhere, no matter what, if it's like a fully remote company. But I'm sure that there's others who would say, no, don't do that because then you're going to be providing way too broad of a range. Because I mean, the payment ranges can really vary depending on where someone's located, for example. Um, so I really recommend looking carefully at the pay transparency laws for the jurisdictions where you're located to see if there's any special requirements. Like we had talked about Illinois and New York, where on its face it implied that it applies to any remote position because anyone from those states could apply and you wouldn't even necessarily know. But then they specified either in regulations or clarified in their laws that no, the position either is physically located there or it reports to a position like a supervisor or an office located there. So yeah, very loaded question. Definitely look at the laws very carefully.
We're almost at the end of the time, so this will be our final live question. What do you recommend for keeping up with all of the privacy laws?
Yeah, so this is definitely a concern of mine as well, especially because I take into consideration international privacy laws as well. I always start by looking for the similarities, especially in the United States. When I was doing my comparison earlier of Oregon and Delaware, I was focusing on the similarities, but then also kind of moving forward and looking at the differences. So I think it'll be easier to keep track of everything if you could see where the similarities are. A lot of times they require data protection assessments or contracts between controller or processor. So figure out where they align in their requirements and then focus on the differences. Otherwise, if you look at every law holistically on its own and try to figure it out that way, it's probably going to drive you a bit crazy, to be honest.
Great answer. Thank you, Jennifer, for facilitating this informative webinar, and a special thank you to our attendees for joining us today. Also, feel free to visit the resource section of our website at AccuSourceHR.com, where you will find our full webinar library as well as other valuable compliance and educational resources. If you have any additional questions, please get in touch with us at marketing@AccuSourceHR.com. On behalf of the AccuSource HR team, we wish you all a wonderful day.